dear, oh dear, oh dear. That's
Yeah,
the trouble with.
Thank you, Peter.
That's the trouble with spending all day in court, isn't it? No,
Yes.
I tell a lie. I tell a lie. Actually, I got my thing finished earlier on, and hey, so that brings us to this week's topic. After last week's episode, I was asked by somebody, please explain what a legal professional does in order to prepare for a trial or hearing. So, to be very clear, trials or hearings, of course, are almost the last stage, if you like, of the legal process, aren't they?
Mm-hmm.
There might be an appeal, there might be some further things down the road, but generally speaking, at this point, a decision is about to be made by a judge, and you have to be essentially on your best behavior, don't you?
Oh, yes, definitely.
But that said, it's not when you're starting the trial, it's not as if by magic, we're not all Perry Mason. We're not going to ask the right questions at the right time. That takes preparation. That takes a lot of growth, doesn't it?
Yes, it does.
Right. So how do you give us a couple of starter points anyway.
Okay, for preparing for a hearing. Well, when you first come into my office, many times people come in and say, well, I've got this hearing slated for a couple of months from now. And basically, I want to know about their case, like who wrote their claim, or did they write their claim, or was the claim properly served? Did they get a defense? I want to know everything. I need to know all of the file, all of the information in the file, evidence that was provided, disclosed to the other party, and evidence that you have that needs to be disclosed to the other party.
Yeah.
So you have to be understanding, because civil procedures of any kind, there's no secrets. You don't have secrets, but you're not a Perry Mason here.
Yeah, normally what will happen is a client will come to the office probably 6 months, a year, or maybe even 2 years before a trial happens.
Yeah.
So there's a whole process of that. There's a beginning process which is about which all has an impact upon this, because when the client walks into the office and says, "Boy, have I got a case for you," normally that's the point when you should be running as fast as you can out the door the other way. No.
Yeah, because they keep saying it's a slam dunk. I just want to tell people there's no slam dunks.
No such thing as a slam dunk. Yeah, you got to watch. You got it on the left-hand corner of the eye, right here. You got to watch out for the judge, because the judge is going to give you a right hook in about 15 seconds, aren't they?
Yeah.
And the point being is that you've got to look out for it, and you've got to be aware. And the point being is that judges or adjudicators want people to be prepared for their hearings, and of course, that preparedness starts at the time when your client comes in the door.
Yeah, exactly. So when someone comes in and this is a fresh new case, nothing's been filed, we take an intake. We find out everything that you need to tell us. Tell us the story from start to finish. Tell us who was involved, who did what, and to whom, and when. We need to know all of the details. We also need to know if you've got any documentation or any paperwork that you can give us or send to us that would reflect about what your story is.
That doesn't mean to say you need all the information at the point when you're coming in the door for the first visit.
We can help you get it. There's something
we can tell you what you need.
Yeah, things like you need to get it from somewhere else.
Yeah, things like
for example, police reports.
Yeah,
things like that, or health or medical reports. So there's different things that you may need.
And so things like text messages.
We gather this stuff up, we put everything together, and we go through the narrative with you, and we ask a lot of questions.
And things like text messages are perhaps some of the most important pieces of evidence out there.
Yep. Text messages, emails, recordings, videos. There's a lot of different things that can be construed as evidence for your case. Depending on what kind of case you have, like there's various types of cases that we have. We'll want to get all of that stuff, and it takes us time to review it. It doesn't matter. Like you can come in here and say, I got this new hot the trot case and it's going to slam dunk. If it's not slam dunk, you can go to court yourself and you'll probably get it, right?
Yeah.
So why do you need us if it's that slam dunk?
Well, yeah, there's a few reasons why a person might come to get legal representation,
Yeah.
and we can come, but that's a kind of topic for another day.
Yeah, exactly.
So,
Yeah.
and
So,
essentially what we need to understand once you've come in, so essentially let's wind the clock back a couple of months, January, February, somebody did something to you and you're coming into the office today, you've tried to resolve it yourself, you're coming into the office today and you're saying, Angela, I need help with this, whatever my legal problem is.
yeah,
Well,
like
at that
trying
point,
to resolve it yourself. I
Yeah.
need to know what steps you took. I
Yeah.
need to know any paper trails that you had. How
Yeah,
did the other party respond? What did they do or what did they say to you? We need to know these things. These are stuff that we have to know, okay? Because they can be very, very important. And we also have to know when things happen because there's deadlines. There's statute of limitations that we have to watch for. The clock's
and,
always ticking, okay? When
and just
something
to let you
happens.
know, Angela, have you got a hello from Robert DePel?
Hello, Robert. Guys.
Okay. Yeah. So essentially, there's a lot of information here, and we need to understand your case and gather evidence. In fact, actually, the evidence in your case, you may not have it all now. And even when we file your claim in a month or two's time, you still might not have it all. For example, if you've got we talk about to you about what is it going to cost to replace this or that or the other.
Yep.
Well, you may have gone to get some quotes and it's going to cost you between 15,000 and 19,000 to repair the bathroom because that's what your people have been quoting you.
Yep.
But when it comes down to it, so you haven't yet done the work, but we have to start the claim process, even though you haven't finished the work.
You got a quote from me from 3 contractors, and I asked you, I said, is there a particular contractor in here that you prefer to work with?
Yeah.
Okay. And who seem more trustworthy. And then we help them, to look at references and so forth to make sure that this is a credible person. So there's a lot of things that we need to look at. Okay. And then we also do some research. Sometimes we have to do research on our clients when they come in.
The other thing about that is
if the case is high profile enough.
Yeah. The other thing about that, by the way, is that so you've got a contractor, is RBC Contracting, and RBC basically gave you a quote of 18,500. But of course, 18,500, what he isn't taking into consideration is when he takes the wall down in your house on a particular area, he uncovers something even nastier. So actually, when it turns around, the actual final, the final fix when he's done it is 23,700.
Yeah.
Right. And he's very apologetic because he says, I never put prices up on my things, but you saw how bad this was. Right. So yeah, we accept that there's actually, so we'd probably have to amend the claim to include that quote of 23,700. Right.
Well, we've had things like where I've had engineers and where I've had to put engineers into cost claims and so forth, where engineers would actually go to the site visit and they would charge for the site visit because they need to do things thoroughly. They need to look at things thoroughly to be able to give you a proper quote. And then when they give you the quote, then they would come back on the site if you pay them to come back on the site to give you an estimate and to do a consulting job as to what you're asking the engineer to answer certain questions. Okay, so these are things like that they would put in place, and then they often also charge to go to court. So there's a lot of things we do. We seek experts. We need to have experts in various ways. Sometimes we need to get some medical evidence. You got into an accident on your bike. and you smashed into a bank building, and we want to know what caused that. And then, and your bike is ruined and you injured yourself. Okay, we need the hospital reports. We need an accident reconstruction report if possible. We need a few things so that we could understand that some of this stuff, that we can get some of this stuff evaluated so that we could find out whose fault it is, what perspective it is, if the accident could have been prevented. We also look at slip and falls. There's a lot of things that have to be considered in slip and falls, such as hip subrogation, medical damages, what prior court said about damages on substantial things. And it also considers the plaintiff too, how old they are, how young they are, income, lost income, various things. There's a whole lot of things that we have to consider.
One of the things that I do with this, okay, so we have to understand your case for, and the evidence that you've got from both sides of the claim. So ones that help you, that maybe your claim is that your claim is something about what somebody did to you, but at some point there might well be a piece of evidence that means that you actually, maybe let's say you called the person in question a bastard or something. You said some bad words about them, and they're holding on to that, which is why they end up with a grudge. Now, with a lot of that evidence that's given, we have to go through it later on with a fine-tooth comb as to what we give to the other side, what we utilize. And in some respects, sometimes when you've said something you've said something bad about the other person, it's often best that you kind of go, well, this happened. There's no holding back from it. Put it out first, because if it looks best, you say, okay, so we've got a weakness in our case, Mr. Judge. It is boom, right? Because you put it out there. Where one of the things that about the other side is they can't then exploit that weakness because you've made them aware of it. They'll know about it, of course they will, but if you try and sweep it under the carpet, they'll make play out of it. One of the things I do with my parties is I often say to them, well, you've got access to a lot of information. You know what's going on. You know what your case is about as much as I do, and you listen to what I've given, the advice I've given you. If I'll probably give you homework, and I'll say you need to give me X and Y and Z, these papers, right? And I will probably in a month's time say, hey, Joe, you didn't give me X. You forgot to give me that paperwork. Can you go refresh it? And essentially, once Joe has gone out and gotten that paperwork, he'll often come up and he'll go, oh, by the way, Peter, is this relevant? And I often say to my clients, hey, just send me evidence that you think might be relevant. I won't necessarily respond to you. Don't expect that I'm going to get you an email. I might just say, yeah, I might just shoot you a quick line back to say, thank you, I've got it. And what I'll do is I'll pile up the evidence into my email until I'm ready to do my evidence gathering section. And I look at my email and I look at the evidence that I've gotten on our cloud server for you. And I put the two together and I make prepare my evidence bundle.
Yeah. So there's a lot of different things that goes into it. We look at your evidence. We look at whatever the other party might give back.
Yep.
Initially, if we're initiating your claim, we will send the initial letter out to the other party. And sometimes you want to get a sneak peek at what the other party is thinking in terms of what they might offer. Okay. And also what they might give us and where they might be falling smack dab on the job. Very often I do that for employment cases because, it's almost always when the boss terminates somebody, there's going to be something owing and something, and very often they get settled behind without going to court. But we offer them something much more than what the employment standards would provide in terms of weeks of severance. So there's different things that we put forward, and we provide evidence as to why. We need to go through and research case law. We need to research what the other side has. sometimes the other side comes up with something, and hey, I bring in the client. The other side said that you did something, you messed up on the job somehow, and this is what they're saying. Can you tell me how to answer to this? Not saying that we're accusing our client of this, but this is what they want to
Well,
use. Maybe they're
and
going
you
to
always
present this.
and you always have to take the opposing viewpoint in some respects, because so hey, so you're saying you slipped up on your job, and you tripped and fell, and your client and your employer fired you because of it. What is the employer going to say about you?
Yeah, exactly. And
Right?
this is where it helps us before we even draft a claim. Because once I talk to you about what the employer says, you're going to give me a reason why you don't believe it or why the employer is lying and so forth. We have to have proper backing on this. It's
Yeah.
not something we just do and say, well, we believe what our client says. No, you need to tell us why this
And
happened. That
there's
there was a
another
dispute
there's
over
another
hours, dispute over money,
yeah.
whatever. Okay?
So there's another thing here what we got to, which is things we may need to do includes interviewing witnesses, researching prior decisions about similar types of cases, as well as understanding statutes and regulations. So this is kind of OREG 2217-22, section 47.
Yeah.
Right.
So these are things that we have to do. Like say, for instance, you're coming in and it's an employment case under the Canada Labor Code. You're not represented by a union, so you're under the Canada Labor Code. And there's specific issues you're concerned about under the Canada Labor Code. So I go through the Canada Labor Code. And there's also some case law that might be representative through the Canada Labor Code that would be useful. And there's arguments that we could probably do through the Canada Labor Code that we probably can't do provincially through the ESA. So there's different things that we would look at, and then I'd present you some options about how you would want to go for it. Most of my clients say, just tell them I don't want to go back to work there. Just give me the money. Eh? And
Yeah.
others say, no, I want my job back because my job paid me well, and I sort of like eating and I like having a roof over my head. So that's another one too. Right? So there's a lot of that type of stuff. So we go
So
through
there's a
that.
lot in order during the entire during the time when you engage us till the actual trial itself. There's a lot of discovery of material. In fact, actually, there's a stage in superior court which we don't really deal with in our practice in paralegals. There's a stage in superior court which is called discovery.
Yeah.
Right. And what is supposed to happen is I will interview your clients, I will interview your witnesses, you will interview my witnesses. And as a part of that discovery, then we're going to make motions about X or Y in
Included,
respect of,
excluded, different things.
yep.
You know,
And that process will take a
affidavit
while.
of documents, different
Yeah.
things that need to go back and forth. Okay. There's always a lot of stuff like that. There's a lot of multiple stages in a civil litigation, like as a superior court action, that
Yeah.
we don't get in a small claims action. But
Yeah.
in a small
And we
claims
don't,
action, even, you have disclosure requirements.
yeah.
You need to provide everything to the other side, and they have to
Well,
provide everything to you. Okay.
I was
So
just going to say,
prepare all of this stuff, and it has to be sent to the other side within certain time frames, as
yeah.
well as
So,
who you intend to use as your witnesses. Okay?
yeah,
And I'm
exactly.
not going to send a witness to the other side, Joe Blow, at such and such an address and phone number, unless I've spoken to that witness and I'm confident that that witness is going to help your case.
Well, and in many instances, yeah. So several months beforehand, before your matter goes to trial or has a hearing, you're going to basically get a notification of the hearing or trial, and that's the point at which you're kind of going to need to actually start to swing things up a notch. You
Yeah,
need to
there's a
speak with the
settlement
witnesses
conference too
if you
before
haven't
a hearing.
already. Sorry.
There's a settlement conference before a hearing.
Well, yeah, I know, but there's not all, not, yes, small claims works that way when
Yeah,
we're not talking about the stage coming up to a settlement conference, although that's an important aspect to it. But
Yeah.
not all trials have settlement conferences. And for example, the LTB, you go to a
Sometimes there's an adjudicative case conference, but not for everybody.
Yeah, not for everybody. And you may have a dispute resolution officer on the hearing block who is going to help people resolve their disputes on the day.
Yeah.
Right?
Because courts are so busy and so backlogged, the best thing they want to do is get everything out of court.
Yeah.
Right? So that's why they try to sort everything out. So you can still mediate things all the way up until the court date. Okay?
Yeah, but at a certain point,
we have serious preparation work. There's a lot of time that we have to put into our trial, all our preparation work, our trial booklets. We have to have our trial booklets. We have to have our book of authorities. Our book of authorities is the act, the regulations, everything that we want to follow, a case law that we have where it's relevant to discuss with the parties. We have all of that stuff. We need to have that in order to bring that and make our arguments.
Actually, when you go to tribunals like the LTB, they're less formal than courts are.
Yeah.
However, that said,
a submission that you have to make.
That said, there is an adjudicator at one of the hearings that I went to requested everybody provide them legal briefs.
Yeah, exactly.
Right?
And
he was preparing
pages long, but then somebody sends a 1,500-page long legal brief. The word is brief.
Yeah. Well, it's not go there and any issues with that. The point being is that at the point when you've got a date from the court or from the tribunal, that's the point where things are going to get serious. That's the point whereby from us, the legal representative, we're not just here, this isn't just the point where we can't slack off at this point. There's no kind of, oh, I'm going to sleep until the eve of the trial and I'll get things done. It'll be fine. No, that's actually where things
get done themselves.
Yeah, things don't get done themselves. You've got to, as you said, prepare a trial book. For a small claims court.
And there's a lot of things in there. For the trial book is everything that you've disclosed so far, plus anything that you intend to raise at trial with respect to that. And there's a time frame. You have to have that in within a certain period of time, at least before you do the trial.
And one key factor, it must be served on the other side.
Yep.
And if you have
with the certificate of service, you have to have.
If you have a book, if you have 3 books 4 inches thick, that must be served on the other side, right?
Yeah, I remember one time I had that. There's 3 large binders I had, and this was a Tarion case, and I had to serve it on the other side, and then I'd bring it into court. When I brought it into the court, I remember there was a small claims matter that was attached to it, and I had to give the same 3 binders to them. And they looked at me and says, Miss Browne, I said, this is small claims court. Small, the word small. But there was enough that we needed to bring up to raise in even the small claims part of what we were doing. And this was a very complicated case. It went on for months. But we finally got it settled at the end.
Yeah, and the point being is that you've got disclosure times. So, for example, typically about a month out from, or maybe even about 45 to 50 days out from the trial, your paralegals or your lawyer is going to be saying to you, knock, 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 knock. I want to finalize all the evidence. Now, as far as I know, you've given me all of these documents in support of your claim. It's got the invoice of July 15th. It's got the invoice of July 22nd. It's got the invoice of August the 1st. It's got the invoice of October the 17th. Is there any more invoices that relate to this claim that I need to add now?
Also, make sure you have contracts. Yeah. So if you signed a contract with the other party that they signed and they have their name on the dotted line, make sure you provide that to your legal.
That's a good one as well.
Because if you don't, they may not admit that.
But the point being is it's no use coming up and waving to me a sheet of paper that is the invoice for March 2022 2023 when you haven't given it to me a month beforehand?
Yeah, you can't. And you can't go
Yeah.
to the court and say, oh, well, I do have a signed contract. Oh, where is it? Oh, it's at home. I didn't bring it. Like,
Yeah.
no, that it's no good sitting at home. It should have been brought
No,
to me. Like,
it needs to be
court.
in the court. Yeah,
Yeah. So
absolutely.
these things, this is why you have legal representatives, because they know the time frames, they know what we need to do, we know what we need to put into the trial brief, they need to know what we need to put in the book of authorities, all of these things which help you win your case.
And it's also at this stage that we consider so it's about 2 months out from the trial date, that we need to consider the building that book of disclosure, what witnesses we're summoning, potentially also wrapping up any negotiations we may want to do. Although that said, negotiations probably get a bit more pointed here, because you're actually saying to the other side, come on.
And he offers to settle.
Yeah, it's how about we settle at this amount? You know we've got a 3-day trial ahead of us. You know that's going to cost your client $5,000. It's going to cost my client $5,000. What about this figure?
Yeah. So we could give them an offer to settle. Will your client accept the X number of dollars?
Yeah.
In exchange, we're not going to trial, and we can settle that. And there's a formal process that we use to give them an offer to settle. And there's consequences for not accepting a reasonable offer. Okay, so if you give the other side a reasonable offer to settle, if you're suing for the full 35, but say you're giving them an offer to settle for that they could pay you 20,000 instead, and by such and such a date within 30 days or something, and then they don't accept it, for whatever reason, that's fine. And then you go into court and have a trial, have your 3-day trial, and then you win $30,000. Guess what? There's more costs added on to your opposing party, who is going to have to pay for that. And this is why they try to encourage people to settle and try to keep as many cases out of court as possible.
Okay, so you're now down to a few days beforehand. You've gone through the negotiation. Let's say you've tried for negotiations. It hasn't worked. There's still always a possibility you're on the court steps. So now, Angela, you're a few days beforehand. You're the weekend before the trial. So what are you doing to prepare for that trial?
Do my Q&A and preparing for some cross-examination where I look for holes in the case that remain on the opposing. And I also look for some very strong points where I just do the narrative and try to make sure that they're all non-leading questions for my own party. Okay? And then for the other side, there's ways that we can maybe try to question where there might be something there. And I go through my book of authorities to make sure my book of authorities is on point. And I try to do the highlighting on the different points that I want to make reference to in the book of authorities, and I want to make at least 3 copies of that, as well as 3 copies of my trial brief. Even though you submitted and you served your trial brief, you want to have an extra couple of copies on hand, one for any witness that might be on the stand, another one to hand to the judge or to the other party in case they don't have theirs handy, because a lot of things is being sent to people electronically. And now they have an in-person trial and everything's in a mess and disorganized. So they have the same organization that you have. And when you refer to a page number, everybody's looking at the same page.
Yeah.
So that way,
that's an important aspect about that, is because, applicants page number 72, or defendants page number 54. Each of
one plaintiff's booklet. That sort of.
You've got to be identifying. You've got to be identifying the evidence brief. You've got to be showing it and working through with it, and knowing that, in fact, that is that you know it by heart, right?
Absolutely.
potentially, because you've looked at the evidence, you also know at that point the potential weaknesses in the opposing party's case.
Yeah, exactly. And this is where you put all of this stuff in there, and you may prepare questions. Sometimes you prepare a set of questions, or maybe subject or topic areas that you want to ask questions on, depending on your level of experience. I basically just need a binder, and know where everything is in the binder. And I don't necessarily have to have a whole lot of script or anything. I tend to have that ability to do that, but
Yep.
not all legal professionals can do that. Others have to have a script that they stick to.
Yeah.
Either way is okay. Either way is
So
okay.
let me say where I go through a preparation. Probably by about a week out, I've already kind of got I know my topic areas. I know where I'm expecting the questions to go. I've thought about what the other parties' questions are going to be. I've looked at their evidence, and I'm looking at their, and I'm often looking at their evidence and thinking, what the heck do they mean by this? Right? Because I probably overanalyze it, if anything, because I'm looking at their evidence and thinking, well, they're putting in a piece of evidence that really doesn't help their case. Why are they doing it? And that's a point where I'm probably overanalyzing it.
Yeah, and
But
I've also been in back in the day when I first started, when like I have about almost 30 years experience at this game, but when I first started, I would often over prepare, do
yeah,
all-nighters, do all of that stuff.
well,
I mean,
I
a lot of young professionals do that, and that's okay. Sometimes you have to
yeah.
learn before you learn how to do things more
Well,
efficiently.
I don't do all-nighters. I tend to look at the topic areas that I need. So I need the topics at which I'm going to build my case upon. And typically what I find is I take my Schedule A, which is the original claim. I take the main topics from the Schedule A and drop a lot of those, take the information from the Schedule A and drop it into my trial book.
Hmm.
That tends to be the topic. So I know on March the 1st, 2023, what happened. And that's driving my questioning of my witnesses. That's driving the story that I've got to tell. And so sure, the story may have modified from 18 months ago when I put my original claim together. And maybe there is an updated claim.
Yeah,
But even where there isn't an updated claim, the story has to be told, and your witnesses are there to tell that story for you. So you have that claim, and you need to break it down to George is going to be telling me this series of items. Abdul is going to be telling me these 4 or 5 or 6 items, because Abdul was the witness to that particular
yeah.
area, and he's only going to be able to talk about these 5 or 6
Mhm.
items. I know that because I've spoken to Abdul in the past, and he's covered it.
Yeah.
And
And also, too,
when I
when you
call
talk to
Mary,
witnesses, one of
yeah,
the things that people think legal representatives do, they think that they instruct witnesses on how to say things. No, we don't. We
we
don't tell
can't.
them what to say, but
Yeah,
we do tell them what types of questions that we might ask, okay? And I want them to kind of answer them. We don't tell them whether they're right or wrong, but we try to find out whether they have enough information about what happened,
yeah.
okay, to be able to go into that line of
And
questioning. Because I don't want to ask a question of a witness who hasn't even been there. Okay.
yeah.
So you
Oh
have
yeah.
to be very careful.
Oh yeah, exactly. So you've got
Because,
to know the
yeah,
limits of what the witness
yeah,
knows.
yeah, and try to focus around that. And
Yeah.
then same as
So
when we
the
go
point,
to our own party
yeah,
and we try to get the party to tell us what basically happened again, and it has to stay with the same or similar narrative to what they talked to us about at the beginning, and we need to work
yeah,
with that to work with that as we keep going, because we don't want to get into a situation like, yes, some details, you can present and then introduce through the witness and introduce as an exhibit. The witness would identify whatever it is, and then they would say, yes, that's the invoice for blah blah blah, dated March
yeah.
20th 2022. So that's the kind of thing that could be done. But
yeah, and the witness is going to then also say this. I gave this to George on the 1st of July, defendant George on the 1st of July, and I reminded him again 30 days later. You can see that. I think that's 2 pages after this on the evidence book.
And I sent him an email.
That type of thing. I sent them an email. I reminded them, and he still didn't pay, and that's why we're here today.
Yep, that's why we're here today.
Yeah.
Okay. And then there's a lot of different things that we talk about, and then we do this. So these are a lot of preparation. It takes a lot of work. Like in terms of people asking us, they come in here, how many hours does it take? In general, we don't bill for all the hours we spend preparing.
No.
We bill kind of a certain amount of hours, but we don't bill for all the hours. If it takes us 10 hours to prepare, okay, we're billing you maybe for half, if we're lucky.
Yeah, yeah.
Right?
Well, I was going to say,
it's a lot of work sometimes in preparing for cases.
Yeah, yeah. I was going to say one of the things I'm conscious of is that at the start of a case, a client comes into the office. You spend 5 or 6 hours with them overall over, say, a month or 2 months, going through a certain amount of evidence, and you write up their preparation and certain about what you're doing about writing up their case. It will end up with, oh, we didn't put this in. Oh, we didn't put that in. So you're prompting them and you're giving them that opportunity to add relevant topics to the case.
That's
but
why
of course, when you've got to remember is you file the case. You go through the negotiation phase, and you're 3 years later down before the court is hearing the trial, and of course, that at that time, you may not remember every little detail about that particular case. Where you are is you've now got to pick up the book again, and you've got to say, okay, I remember that now, and I remember this, and I remember that. So there's a certain amount of reading just to get back to where you were 3 years ago.
Yep, exactly. We have to go through the entire file, review it again.
And you don't charge. Typically, I wouldn't charge for repositioning myself to where I was for 3 years ago.
I don't, because you already did that.
Right? Yeah, I'm charging. What I'm going to charge for is now I'm putting your evidence together in a book. Okay, so I've got this picture that shows the hole in the bath that was chewed through by the rat. I'm putting that one in there. I've now got the picture of the hole in the drywall that was by the flood that happened in the bathroom. And that picture's going in my evidence book.
And the third picture is the rat itself.
So I'm going also through these. So I'm then the next picture I'm opening is the broken dining table. That's a different part of your case. So now I have to resort that and put that in that part of your case. So now I've got an evidence book that goes in a logical order, right?
Into different clusters or categories.
Yes. Yeah. And the point being about that is that you don't want to be taking the adjudicator, the decision maker, the judge, or whoever through the file. Your Honor, it's on page 54. Now, Your Honor, that's on page 17. Your Honor, that's on page 92. Your Honor, that's on page 8. No. Let's be going 1, 2, 3, 4, 5, 15, because actually, let's say you've got a contract and the relevant we did pages 1 to 4. 1 to 5, right? That was the contract. We can, because we need to put the contract in its entirety, because the judge may have some questions on that, right? We can then skip to page 15, which is the next document.
Yeah.
Right? So now here's the promise to do certain bits of work. Can we discuss this aspect of the case?
Yeah, exactly. And then there might be witnesses to show who actually did the work or didn't do the work. There's a lot of different things, but you have to do. And then this is a lot of preparation. This is one of the things that a lot of people think Like they show up and they go on judge duty. They think this is all that happens when people that, oh yes, I have the picture. Judge Judy asks, oh, do you got any pictures or photographs? You got the invoice? Oh yes, here it is. Hey, and they hand it over, and the bailiff picks it up and gives it to the judge, and then she says, oh, I don't believe you. Oh, why believe you? They said, yep, judgment for the plaintiff for such and such. No, it doesn't go like that. In Canada, all these small claims courts, they go, even the small claims court, they go through a regular trial and adversarial process.
Okay, so let's talk about something else that is on the banner here today, right now. Preparing the opening and closing statements. Now, I will prepare my opening statements, which will usually say, Mr. Adjudicator or Judge, we're going to be hearing today, blah de blah, and George has a claim against Mary for X, and the what you will hear in evidence will be whatever, and I think you must conclude that my client therefore is owed $10,000 from the defendant, that type of thing. Right.
Like this is one of
your closing also is pre-prepared to a large extent, but to some extent what you have to do with your closing is say you heard in evidence X or Y, because and you can't say you heard in evidence Z, because if none of the witnesses talked about Z, even though you asked questions that were related to Z, there's no, Z is not in evidence.
Mm-hmm. Yeah. Like on my introduction, I always introduce the parties. I introduce the claim. I introduce what happened, like basically what is being claimed. And when you do an opening, you do not talk about evidence, but you just introduce what is alleged. And you also introduce the parties so people know how each will relate to the claim and how the court will hear about each of them, and possibly in what order, if you could figure it out, if you figured it out by then with the judge. Okay? And then the closing, when we conclude, as I said, okay, we have heard testimony, the facts on each step. Usually I try to do the narrative in the order it happened. And then I try to bring, you heard from this witness, you heard it from that witness. And then I get into the law. Okay? Then I talk about the legal questions are blah, blah, blah. And then I go into the book of authorities, start picking my law out of that, and then saying, okay, now this is where the book of authorities would lie.
I didn't talk about the book of authorities, but I've usually got those ready, prepared for my closing statement. Some of the worst
aspects, like it's less formal, like you don't have to submit a book of authorities for tribunal, but you could identify.
Actually, I think it's a good idea. It's a good
idea. And sometimes, you can even just submit it to the adjudicator afterwards if you want to give it to them, because sometimes they will ask for it, but it's not something you have to formally put together.
Yeah.
But small claims, they might ask for a book of authorities and have it where you have table of contents, case 1, case 2, case 3, like Smith versus Jones, Giblett versus
you taking my case, Smith and Jones.
Yeah, so Smith, whatever. Yeah, so these are things when you have and you make the arguments about what the case was about and where it applies to your case and why your case meets any particular tests.
Of all the cases, I've got to come up with one that includes Donahue and Stevenson, or Carlisle and Carbolic Smoke Pool. Got to get those into a case.
Colligan is good. Yeah, that's another interesting one. Yeah. Yeah.
Anyway, so that's been an interesting kind of discussion, and that's kind of just to show you the whole point about this show was we were asked at the very beginning, as I said, to what does it take to to prepare for a trial or hearing, because the reason that person said is you always sound so perfect there. No, a bag of nerves. I'm biting my nails. I'm shivering under my skin.
Yeah, exactly. Like
How about
there's a
you,
lot of
Angela?
that type of stuff. It's just that, like, yes, everybody's nervous, particularly in the first few years of practice. You're always nervous. As you go, you start realizing, okay, I mean, this judge is another human being. I'm another human being. My opposing counsel is a human being, probably just as nervy and upset as I am. So there's really no point in getting all uptight, and you just go forward with what you have and you develop your own system. Like, as
Yeah.
I said, I have a particular system for developing my trial strategy, and Peter has his own system for developing his trial strategy. Everybody eventually develops their own that they're comfortable with, that makes them work as effectively as possible. Okay?
Mine is smooth, smooth, smooth. Watch out for the fist.
Oh, yeah. I just have classical music playing in the background when I prepare, so I do well.
Yeah. Okay. So actually, and we all have different styles, and just because hey, if your legal representative is the type, we're banging on
Mhm.
the desk all the time, that doesn't mean to say they're any better than the person who's, you will hear from me today in smooth tonal voices. It doesn't mean to say that they're necessarily any stronger than the person who's a smooth voice. They
Yeah,
often like to think they are, but that's
yeah,
all. It's all a matter of, actually, to some extent, it's probably about in your opening of the court case, or whatever, opening of your trial. Probably the best thing you can do is listen to the adjudicator, listen to the decision maker, because when the decision maker starts to, or look at the decision maker, because if the decision maker has a look about them that is like, what are you doing there, kind of thing,
yep.
tone it down, change your tactic.
In a court system, you have to realize it's a very conservative system. They do not like if a person goes in on strong, on all cylinders running, it's not going to be
Yeah.
as presentable to the judge as somebody who presents more in a very calm and a rational and effective manner. And
Yeah.
wasting court time by making repeated arguments, asking repeated questions to your witnesses, that sort of thing, could drive the judge crazy. And
Well,
usually the opposition will go objection asked and answered. I raise objections all the time. I love doing that.
the other thing, of course, may well be that if you're the kind of bombastic person and the judge doesn't like bombasticness, that judge could end up fining you.
Yep, exactly. Especially if you talk over the judge.
Yep.
Okay. Or if he tries to say, okay, you got 2 minutes, and then you try to do it 10 minutes, that's
Yeah.
going to be too much of a stretch.
Yeah. Yeah.
Okay, the judges own the
Well, in
courtroom.
fact, yeah, I was just going to say that the judge owns the courtroom. The judge actually is the timekeeper. The judge is the person who's looking at the clock and saying, it's 5-1.
Mhm.
And he's thinking to himself, do I finish it at the end of this question? And he might say, Miss Browne, how long is it before the end of your questioning at that point? Because he might say, so you tell him, I've got about, I suppose, 7 or 8 minutes left, Your Honor. I might say, oh, in that case, okay, we can delay lunch for a few minutes because
Yeah.
we'll finish at 10 when you've finished, okay?
Yeah.
Mr. Opposing Counsel, are you happy with that one? And usually there's some kind of recognition at that
Yeah.
point.
There's a discussion
Yeah.
because the judge has to mediate between hearing all of the facts and making sure each party has their say in the court, as well as making sure the court case is not being inefficient.
Yeah. Yeah, because he's looking at the time. He's looking at the time with this. And actually, I would say also That's the same with when you're talking about tribunals and hearings that are being held on Zoom. One of the questions, though, with Zoom is that there are often one of the questions that bother me is somewhat is that, yes, okay, so you're in an LTB block, for example, and there's 15 other cases going on and you're waiting for your turn. Sure, you can be going to the bathroom at the same time. There's a minimal risk when they're in the middle of another hearing that the adjudicator is going to be turning around and saying, Peter Giblett, are you there and available? We need to start your matter. And if they do, and you happen to be in the bathroom, they move on to somebody else.
Yeah.
If you know, and so you got to take your breaks when you can take your breaks. And the trouble is, some of these adjudicators that I've had more recently seem to, I think what they do is they've made themselves lunch, and they're sitting with the lunch bowls on their left, and they eat as they go, and they kind of go, well, I'm going to take a 2-minute break, and of course their bathroom is literally outside the door, and they know there's nobody in it. And at that point, you're kind of going, yes, crossing your legs. Hey, I want to go to the bathroom as well, Mr. Adjudicator, but I might have to wait 15 minutes. Don't be afraid to say it.
It's very difficult. Like adjudicators vary. Some of them, like they're in charge of their own hearings too.
Yeah.
So if you have an adjudicator and have a day string of hearings, okay, some of them take an hour break for lunch. Some of them don't. They must go all day. Particularly the types of cases that they're hearing that day, like a landlord-tenant board hearing that's going, that might only have 2 or 3 cases for the whole day. They may choose to go all day because they want to make sure all the cases are heard in the day. Yeah. I had one who was getting really, really frustrated. She was saying, okay, she says, have you guys got to a settlement? Like, not talking to me, but to other people who are in the courtroom at the time. She's, guys, offer a settlement so that I can have some more court time for this other one that needs some more court time. Okay? So they're very different, how they operate. Yeah. So, and you work with them, okay? Because sometimes if you're a representative, and sometimes if you have other obligations, like you may have an afternoon obligation in another room, you might have to tell the adjudicator in the morning that you have an obligation in the other room in the afternoon.
Yep.
So they can plan their time appropriately for you.
Yeah, exactly. And that's an important thing. Your communication within the court, within the tribunal, is a vital aspect, because, for example, if you need to be somewhere else for 3 o'clock, normally they'll facilitate it.
Yeah. Like I've had settlement conferences at the same time where I had to run up to another court, or then I had a morning adjudication, which was an all day. And I said, I have to get out up here at 2 o'clock for a settlement conference. Okay? Yeah. So I was just kind of wondering if we could hear the bulk of this case today. And if it has to go on to another day, that is fine. Okay? But I just want to make sure that I'm not going to miss anything.
Well, and also talking about timing, I've had one, I appreciate it when an adjudicator or judge, well, judges in courtrooms, you generally know that it's going to finish by about 4 o'clock. And the timing is typically 10 till 1 and then 2 till 4. But sometimes what we've had is the judge might start the afternoon session and say, I can see this might go till 5 o'clock. I'm prepared to wait till stay till 5 o'clock. Yeah. I do have a 6 o'clock though, but it means I need to be out of here by 5:05 at the very latest. Yeah. If you can be mindful of that, I would appreciate it. And actually, what I also would like to say is, we're talking about preparation today, about our preparation as legal representatives. Think about the adjudicator for a moment. There are some adjudicators, for example, today in the hearing this morning, the adjudicator said to me that there were a couple of concerns that he had over some paperwork that had been put into the case. It's weird because this was a redo hearing, and the previous adjudicator had not noticed the same thing. But hey, we are where we are. And so the adjudicator pointed that out to me, as it happened, we didn't need to worry about it. We got this thing settled, right?
That was a pretty sharp adjudicator too, the one
Yeah.
that you told me about. Yes.
Yeah, and that was appreciative because, in fact, what it tells me that many people who are on the bench who are adjudicating matters do look at the paperwork seriously. All right. I actually sat with the judge many years ago when I did my bar in England. I sat with the judge because I was always interested in what they do at judicial level. And actually, the first thing the judge handed to me was like this docket about, 10, about a foot and a half thick. And he says to me, have a read through that, and see what you think about it. So I got about 6 pages in, and he says, what do you think so far? And I'm like, kind of, I told him what I felt about the case. And he said, I said to him, have you read it? And he said, no. Typically at this stage, when I'm not getting onto the docket until the afternoon, I'm not going to actually read it until I'm actually knowing that this is going to be set down for trial and a trial is actually happening. He said to me, there's several things that could happen
And
here.
if he's seized?
Sorry?
And if he's seized?
Well, yeah, and there's several things that could happen here, whether he's seized or not. The question that could be happening is that, and this is exactly what happened. There's going to be preliminary matters of discussion. He said, so there was. We came back in the afternoon, and there was exactly that, preliminary matters that needed to be handled, and that was the first day and a half of this hearing was all about preliminary matters. And it hinged ultimately upon this question about whether this person was read their rights at the appropriate time.
Mm-hmm.
And the judge basically listened to the argument of both sides about when the rights were read. And, once they'd had that discussion amongst the two representatives, two barristers, the judge made his ruling. He actually said that they should have arrested her at the house before they took her to the police station, because he believed that that they had enough evidence at that point. They should have arrested her when they were interviewing her at the house. Right. And at after the trial, he basically was over and we were back in his chambers. He said, do you see why I said at the beginning of the thing that I don't read beforehand? Because that kind of voir dire that went on was all about evidence and whether evidence should be admitted into question. I said, had I admitted that evidence, of course, I would now be duty bound to read it, because the next step would be that we'd be going to trial.
Yep.
Right. And
exactly.
So it's important to know what the judges and decision makers are doing, because in fact, how they operate. And I was really grateful for that particular judge and the insight that he gave me into how a judge works.
And this is why you have to admit evidence, and things have to be put into a proper thing.
And that's why he's got this book that's this thick. That's why he's got the book this thick, right?
Well, I submitted all of this. I submitted this big book there. Yeah. You should have read it. No. You have to submit these things, and then you highlight where it is. And yes, they do go through it, and they make a decision on it.
Yeah.
And they do listen to the recordings, and they make a decision that way. Oh, your personality shows. Oh, I'm busy watching the PWHL. I'll catch up later.
Yep. Okay. So, couple of final things that we need to have to say. Your favorite part of this entire thing, Angela?
Yes. This session has been about general legal issues. I don't know whether this was exciting for you or not, but however, this is something that's very realistic and part of the legal profession. If people who want to become part of the legal profession, that's what they have to deal with. But whatever we say on this show is not legal advice. We cannot give you legal advice on this show. Like, we can't have a phone line or hotline calling up, and people can call up and ask us a legal question and us to answer, because we do not give legal advice on the show, but we talk about legal issues, whether it's in the news, whether it's practical legal issues, whether it's in the courts, or how we address it. For anything specific to yourself, you need to speak with a lawyer or a paralegal. We'd like you to contact Invictus Legal, okay? But if you have another lawyer or paralegal, that's all right. But you do need to speak to people. But if you do need to contact Invictus Legal LLP, our number is 905-688-5598, or look at our website on https@weareinvictus.legal. Hey, thank you too for attending, Robert. And there was somebody else earlier.
Yeah, that actually, your personality shows. That person watched us last week. Actually, they made some comments after the show.
Oh, interesting. So I better take a look at that one.
We do appreciate that, and
we appreciate all our comments, people. Yeah. And if you'd like us to talk about something, and if there's a legal issue that really excites you, or you want us to talk about it, put it in the comments section, or just send us an email to the email address at Angela@weareinvictus.legal, or Peter weareinvictus.legal, or you can just go to our Facebook site and then put it into the messaging. So whatever you want, just kind of give us some ideas for future shows, and we'll try to accommodate.
All right. Well, there you go. And we do appreciate you being here, and always appreciate everybody who wants to tune in. And one of the thoughts that I'd like to actually do is I'd love to interview a lawyer, or judge, or or another paralegal to get their perspective on a few things.
Oh, sure.
Yeah. So let's see if we can make that happen. And I'd really love to interview a judge or an adjudicator.
Yeah, well, if we could start to drag some deputy judges up here and see what they do, and
yeah,
or an adjudicator. We could get Sean Weir on here and talk about digital first philosophy.
That would be an interesting topic. Yeah, that's for sure. All right. Well, thank you. Thank you, everybody. Sorry?
Sean Weir's been taking some leadership on the whole digital strategy for Tribunals Ontario, to bring everything to Zoom, where we have our Zoom hearings. It's not all on Zoom, but 99% of it is.
Yep. Okay. All right. And we'll have to do better on timing if we're going to invite a guest.
Yes, exactly. Right. Let's remember when it's Wednesday. Okay.
Yep. All right. Thank you, everybody. And we'll see you next week at 6:30.
Take care.